Good afternoon, everyone. Welcome in Castel San Pietro Terme. I am Laura Calafa, coordinator of the project DXB Identities on Move. This afternoon will be really important because we will start the final conference of the project. I would like to give the floor straight away to the president of ANUSCA, President Gullini, for the welcome greeting, and then we will go on with the start of the conference. Thank you, President. Thank you for hosting us. And I would like to ask you all a round of applause for the President. Thank you, President. It's really hard speaking here in front of you, but after also this word it's harder. But I would like to expand these words to all the people that cooperated in this project and also to the different colleagues, experts in civil status that cooperated with us. For me, it's a pleasure and an honor to host in the Academy of the Italian Registers the final conference of the project Identity on the Move cross-border documents. We are grateful to Professor Laura Calafa, scientific responsible of the project, to have involved ANUSCA in this initiative that allowed us to cooperate with different professionals of the highest international level and also to ensure our contribution, albeit modest, to promote the free movement of civil status records between countries. And this is fundamental to promote the integration and the relational life of people. We are convinced that the investigation carried out during the project's activities in the 24 countries of the Union, in addition to Albania, but also the insights coming from the analysis of the results, will provide the European Commission with useful elements to assess the opportunity of launching an information campaign aimed at citizens, but also to stimulate the training activities of civil registers and also of the different professionals in the field in the different countries. This will allow us also to verify what room for improvement there is in the current legislation, also considering the different international agreements on the topic, in order to make life easier and less bureaucratic for EU citizens who live for reasons of work, study, or life choice in countries other than their countries of origin. So, thanks to the experts who cooperated, not without difficulty, in particular to lawyer Alexander Schuster for his commitment and the quality ensured over the past 2 years to achieve the goals of the project. But also thanks to Dr. Giacomo Caldacci for the practical handbook on the regulation that will be presented today. And also thanks to the different highly qualified speakers who will take the floor in these 2 days, bringing their personal contribution of knowledge. So, an heartfelt thank from my perspective and also from the point of view of the association that had the possibility to show this training campus created by ANUSCA, and we hope that this will be the start also for other national and international activities that we want to implement in this academy. Thanks again, Professor. Thank you, President. It's an honor for us being here. I don't know if we have some problems with the audio. For us, it's an honor being here, also with the academia. Universities that cooperated and designed DXB are universities that pay attention to research. Research that is focused also on the dialogue with partners from the local territories. The academia world creates new ideas, theories, and also constantly works with the different operators of the civil status that have to implement the different records. The circulation of document to promote the different rights is one, maybe the highest representation of what we expect from the European Union. Today's session is part of this project that today has the final conference, which is dedicated to the different hurdles to the circulation of people and also of records. We will also present the different important deliverables. It was really hard to create these deliverables, and I would like to thank all the international partners because the comparative research is the base for the implementation of European law. I would like just to welcome you and thanking you, both those present here and those connected from remote. As you know, we have the different handbook today in Italian, but we will have also different manuals in different languages to understand how civil register have to implement the regulation. We will go on also, besides the limits imposed by the project, to build trainings with operators, because especially in the next step, that is to say after the project, it is important to enhance the results of the project itself. So I would like just to thank all those who participated in the project. A special thank to Alexander Schuster, who is in the last row, but he is humble, he is a hard worker. So thank you, Alexander. As you know, the universities that worked for the design of the project are the University of Verona, the University of Bergamo, the University of Innsbruck, and also the University of Graz. Also colleagues of the of from Greece, so University of Thessaloniki, who are here. So I would like to give the floor to my colleague coming from the University of Graz for the presentation of the first session of today. Thank you, Gregor Christaldo, also for following us. We have followed him and he also followed us. So thank you, Paul Paprader, you have the floor. I know that there are very few people who talk in German, but I'm sorry, I will go on talking in German. I would like to thank all those who organized this conference. First of all, thanks to Alexander Schuster, who was the first to initiate this project. He contacted me many years ago to start working on this project. So after some difficulties, we started cooperating, and for me it was a really it was a pleasure. I will go on now with German. This first part of the study is a comparative part, also of the results of the project, that on the base of the relationships of the country were compared. As also Laura Calafa said, she mentioned that we gathered a series of reports of the different countries, but when we analyzed the situation of the different countries, I don't know if we can see that on the screen, if we can show the slides. We have a part in which the different reports of the different countries will be available in the future. The first result is that the different requests are not relevant, they are not known, and even though they are known, they're not implemented. At that time, when we proposed this project, we didn't have official results. And we didn't know how to implement it. We didn't know if a declaration from the European Commission was needed, and it took place on the 16th February 2020. At that time, the Commission had to provide the report to provide guidelines on the use of this regulation in the different countries. The results are now available. We gathered experts' opinion that are useful on to understand how this relation is used in the different member states. But how did we get here? We had to focus on comparable information, and this is why that we created a survey, a questionnaire that was evaluated also by different experts. It was not possible to have reports from every member state because there are some member states in which it's hard to gather the opinion of the different experts. The first part was of 22 member states. Now we have 24 member states plus Albania. These reports laid the foundation to create a comparison that was elaborated by Alexander Schuster and that will be published this autumn. Paul Patrider will talk about this document. He would also talk about the choice of the different countries, so how the different countries reacted to this regulation. He will also talk about the report of Germany and Austria. Alexander Schuster created the comparative report and will describe what are the main issues he detected. Before giving them the floor, I would like to present Alexander Schuster. He is the father of the project, as it was also said. The idea came from him. He worked in different fields. He graduated at the University of Graz in Austria, and he works as scientific collaborator, and he was the coordinator of this project. He also worked in the project Equal EUs, and then he developed the idea of this project. Alexander Schuster is also a lawyer focused on fundamental rights. He is a pioneer in these topics. Paul Patrider studied at the University of Innsbruck. He's now studied international private law. He focused on different projects on the regulation of public records. So he's an expert of this field too. He also organized, together with me, an event focused on the circulation of public documents in Austria. And we are really proud about that. So I'm really happy to be here to present the results of my project. And also, I will talk also about the questionnaire we developed. We made a comparison of the different projects focused on public records. I would like now to give the floor to my colleague Alexander Schuster. Thank you. Well, I don't know why it doesn't work. We will start now. We are trying to start the presentation. I will talk in Italian now. We chose to focus on this project because sometimes some financing programs of the European Union, some European member states are excluded, like for example Denmark, because this country decided to opt out some years ago, so they have to focus the regulation. Well, sorry, it was more or less 20 slides. We don't worry about that. So we excluded Denmark from the countries that could benefit from the financing. Our program included Montenegro and Albania as candidate states that could be included as partner states. So we chose to include the highest number possible of countries. As Gregor Kistandel, we involved 24 member states, more Albania, that wanted to provide us an idea on how the civil statute works in Albania. So to imagine in the situation in which Albania could become a member state, how the regulation would be implemented in Albania. Even though Albania are quite far to get ready for the implementation of this regulation. It's clear that giving you an idea of what we gathered with 25 national surveys, also thanks to the partner AVS, we got some insights in the pilot project, in the pilot phase of the project from Scotland, because when the project started, the United Kingdom still was part of our family until the 31st December 2020. I'm sorry. So for some years, they had a situation in which they implemented the document, they received multilingual forms. So we also have insights on the civil status in Scotland to have an idea also of countries of common law. the country is quite far from the implementation of these regulations. It's hard to give you an overview of the results because we had 25 national studies, because thanks to our partner IBS, we had some hints of the pilot phase of the project from Scotland, because when we started with the project, the United Kingdom was still part of our big family until the 31st of December 2021. So for some years, they also implemented the regulation. They released multilingual templates. So we have also some information from Scotland just to have an idea from common law countries. Ireland as well is another perspective of common law. Providing you the results of the claims we gathered in this period would be useless because that would be too much information. So we chose to focus on the hurdles what concerns the implementation of the regulation that were part of our research. I would say that the focal point, considering national relations, were not particularly relevant. Some people told us that the national authorities changed its denomination, so we had a problem what concerns IMI, the System of Information Among Member States, which is the digital tools that we use to communicate among authorities. Because when there is a doubt on the document, which doesn't present an apostille, can be justified, and the receiving authorities can ask for clarification to the releasing authority. Otherwise, we didn't find sorry many hurdles. This is the main issue. This regulation, as was said, is not widely known and implemented. And it's clear that when you don't use a lot of regulation, there are very few issues arising. So the fact that we faced very few hurdles is connected to the fact that this is not a highly used regulation. Concerning countries having statistics on the use of the implementations, the main hurdles refer to different multilingual perspectives, the different multilingual templates, which are released by the convention, the European Convention. On the contrary, we have very few released documents concerning the regulation. We have also to highlight that the regulation is not only related to the release of the templates of these forms, because one of the pillars of the regulation is the lack of need of an apostille. It's clear that every public document, public record that is released by an authority doesn't need any more seal and can be used directly. So it's really hard to analyze the use of this pillar. On the contrary, it's easy to analyze the use of the second pillar, which concerns multilingual templates. What are the statistics that will be presented also by different states? These statistics are based on centralized systems because, so for example, not Italy, because these documents are released by municipalities. When there is a centralized system for the release of certificates, so for example, an online system, we have a national data bank, for example, in Belgium, in the Netherlands. This doesn't happen in France because they don't have an automatized method to release certain documents. So, for example, today in France, you cannot download multilingual templates. But concerning this aspect, we can have an idea of how many documents, how many templates we have at our disposal. What concern the use of regulation is that when we ask the experts to present us with circular letters, that is to say, formal documents concerning the civil status or criminal record, it's clear that these records are released by the central state. Of course, we have some exception, like for example, Spain, that has some differences what concerns the de facto unions and registered unions. Of course, this is part of the statal competence. Usually, national competence is connected with the competence of the municipalities and the territories. When the competence is centered on the state, like for example in Croatia, the state authority is decentralized, it's present also throughout the territory, which takes care about the management of national databases. We have reported that when we have these kind of activities, decentralized activities, we don't have a lot of guidelines. Of course, if the regulation is not that much used that much, very few issues arouse, very few doubts arouse. We have found on different websites, of course, official website of the secondary administration, we found some wrong information, wrong guidelines. For example, a few months ago, I found a circular letter from the city of Milan that provided citizens with wrong guidelines. Of course, another issue concerns the differences between residency, domicile, civil status. There can be the different authorities focusing on these issues. For example, what concerns also criminal record or marriage certificates, we have different authorities. So a lot of times authorities who are not familiar with legalization apostille have to provide guidelines, and these guidelines could be wrong. Another issue we reported is that some member states do not cooperate with the Commission. For example, in Italy, if we look at the examples of Italian documents, we will not find them. So you can't have an idea of the kind of documents that Italy should release. Ireland, for example, didn't provide information on these documents. That's quite strange. Maybe these documents were released in Gaelic, which is the first national language of Ireland. So maybe they are being translated from Gaelic into English. So on the platform e-justice, we don't have a web page in English concerning Ireland, and this is a huge information because information are missing also on the web platform concerning the regulation. So we didn't have a lot of information from the rappers, so we have to investigate deeper on the use of the regulation, also thanks to short reports coming from registers of our partner, EVAS, which is the European Association, including 9 association of registers coming from 9 different countries. So we gathered information also from the minutes that are available online, coming from the expert commission of the European Commission that met last week. So also from the ad hoc committee of the European Commission, we could recognize some issues. For example, last week we talked about religious marriages. This is a quite important issue because the project is a blend of practical aspect, that is to say register who have to implement the regulations, and scholars. So there are two different words that combine both theory and practice. So one of the issue that arose is the one of religious marriages. Italy has to partner. In Italy, of course, religious marriages have always been prevalent in the last years. Today, it's not like that because the numbers of civil marriages are higher than religious marriages. And we have an international agreement present in Spain and Poland, in Croatia, which is quite present throughout states. What what is a religious marriage? Of course, there is a priest who can celebrate a marriage, which will be based on the religious law, and the judges of the church can annul the marriage according to the religious law, not according to the law of the Italian state. For example, in Italy, if a marriage is annulled, is considered as if it was a religious marriage. So there is the difference between religious and civil marriage, and we have to define how should we manage the annulment of religious marriage and civil marriages. So we wondered, marriages according to canonical law is similar to different marriages like Orthodox marriages, but also the marriage is carried out by different kinds of religion churches. So we wondered if we should consider this certificate of marriage as a certificate released by a third authority, that is to say, by a public officer of a member state. And if we analyze the definition of public document, it's clear that a document on marriage is a public document. because this is also enshrined in the regulation. But these documents should also be released by an authority of the member state. But what is an authority according to the EU Regulation 2016 1191? A public authority, of course, is different from authorities from the church because, for example, in Italy, a priest is not a public officer of the member state. Or it could also be an entity that acts according to its official capacity and is authorized by the national law to issue or receive public documents covered by the regulation or a certified copy thereof. It's clear that a public document is released by an authority and the authority is authorized to release public documents. This is a circular definition because a public document is released by an authority. An authority is a body that can release public documents. So this definition doesn't help us to understand if certain documents are enshrined in the regulation. Of course, we have established churches that are acknowledged within member states. For example, in Finland, when church is still highly connected with the state and celebrates marriages that are directly recognized also by the state, we have a situation in which a public officer of Finland cannot marry people outside the state of Finland, but a religious authorities can do that. And this is an information coming from the official website of the Finnish government. So these information, these situations are quite different. Are quite different. Sorry. So what is the conclusion? On the one hand, a religious marriage should be registered in the member state, should be treated as a marriage celebrated in a third state, so a country that is not part of the European Union. This would mean excluding from the scope of the regulation more than the half of the present marriages we have today. That this would mean changing the regulation. That is to say, uh, considering these marriages as public documents released by third states. Another solution, and this is why I mentioned the expert committee of last week, Cyprus, talked about this issue concerning religious certificates. And what was their solution? They registered in the archives of the member states the certificate. Of course, this is a transcription. It's clear that the Italian authorities can release the marriage certificate, but this public record comes from a third authority. It's not an Italian public officer who released that certificate. So, from national reports, we found that this issue hasn't been perceived, hasn't created problems. So, these documents circulate in this way. It's clear that Cyprus has tackled the problem, that the issue that we thought about. What concern multilingual standard forms, there is a case that was not present in the report. What is the case? That is the case concerns the denial of releasing multilingual standard forms when they have to be used outside the European Union, for example, in the United Kingdom. I think that we had a misinterpretation because if we analyze Article 2.1 concerning the objective of the regulation, that is to say, issuing public documents to transfer it to another member state. This implies the idea of the presence of two member states. For example, if a multilingual standard forms is used in the US or in the UK or in Switzerland, these are not member states, so it's a third state. So the directive is to avoid the releasing of this document. We think that this is not right because in this situation officials cannot investigate on the authenticity of the document. Of course, we have to focus on what is the target language because we have to go from one language to another language. I have to choose two official languages for the multilingual standard verbs. Of course, if I use this document in the United Kingdom, which is not a member of the European Union, the authorities of the issuing state cannot release this document. However, we think that we have to provide EU citizens the possibility to use these documents also outside the European Union. I can use these documents within the European Union, but also in the common market, but also in the UK or in another state. Another misinterpretation that was present in some national reports concerns extracts according to the conventions of ICCS, because they say that you cannot say the use the this system within the civil state. It's clear that in no national report we found that the extracts of documents according to ICCS are not public documents. In the member states, these are documents released by registers. So these are public records. For this reason, it's not possible to consider these extracts as not part of the definition of public documents of the regulation, even if their origins are part of the convention of the ICCS. So these extracts can be compared to different documents that are defined as public documents. So as they fall within the regulation, they can also be added to a multilingual standard form. For example, if I need a language which is not part of the standard languages of the ICCS, because of course we have a standard multilingual form which is connected to a public document. Of course, there are many states that release their documents in different languages. So I can also add a multilingual form to documents that already are multilingual. So, for example, in Sweden, I can also release documents in German and add French. So also ICCS documents are considered as public documents that can be translated according to the multilingual forms. These documents can also be used to verify the reasonable doubts on the authenticity of the document because the seal that is present on a French birth certificate is also present on the extract according to the International Commission of Civil Status. So the process is exactly the same. So I can use the same system to solve the same questions and the same doubts. Of course, I cannot use these tools to solve specific features of the International Commission. As the regulation says, you can use these documents, you can't use these documents for different purposes of the regulation other than verifying the authenticity of the document. Another hurdle that we found is concerning e-docs, so digital documents. It's not the regulation that creates new issues, but we already had these issues before the implementation of the documents, of the regulation. So, for example, when we don't have a paper apostille on the foreign document, we have to focus on how to solve the dichotomy between digital and paper documents. From national reports, we have different diverse situation. Sometimes we have problems in accepting electronic documents. For example, when a state, a member state, do not release e-docs. On the contrary, states who release e-docs can accept them. So, for example, Austria. But we also have states that says, for example, if the e-docs complies with the regulation. So, for example, it presents an electronic signature. I can verify them and I can accept this kind of document. Another issue concerns document released third country documents. Scholars reported some problems connected to incremental documents. For example, if I have a divorce certificate, this marriage could be celebrated in a non EU state. So the documents of the marriage come from a third country, and I have to add information, an act concerning divorce that was carried out in a member state. Also, the change of name could represent an issue. So, for example, a citizen, but also a non EU citizen who has to change name. For example, a person was born in Argentina but changes sex in France, and we have a public record certificating the date of birth and the place, but then certificate also new elements coming from an EU member state. So we have to focus on how solving these problems. Another issue, for example, concerning the extract of ICCS, is understanding the origins of our certification. For example, maybe the marriage was celebrated in the US, but the document was released by the Italian embassy in the US. So, how should I manage my documents in these situations? So, what is the origin of this document? Is this a foreign? record or a European record. Of course, this is not an objective data, and mainly the limitation of the regulation on records coming from non-EU members creates a lot of uncertainties. Of course, it's clear that we have to interpret the regulation to avoid that people who were born outside the European Union can't move freely within the European Union because the history of their civil status took place within the European Union. So usually you shouldn't ask for the legalization, but not every member state is familiar with legalization. For example, in Sweden, they don't have legalization, but in Italy, we have to define what kind of public records need an apostille and what kind of public documents do not need an apostille. So we understood these hurdles, a lack of understanding of this part. A part that you will find in the commentary concerns the exchange of good practices according to the regulation. We talk about public documents, certified copies, and certified translation. So it's clear that in this case we have an harmony because if I study how to use all of these stages in my head, the regulation also takes care of limiting fake certified translations because also these kind of documents can move freely. So the tools are the same. As you can see here, the regulation used the word accepted. This doesn't mean, as before, accepted from apostille or formalities. This means that member states must accept certified translations. It's clear that states cannot say that they do not accept translation because they require an apostille. Otherwise, to understand the meaning of the word accept means that state cannot have a discussion on the correctness of the translation. The objective of the regulation is avoiding the investigation on the content. So on the contrary, the effect would be binding for the state. So the content of the translation couldn't be questioned. But this is not the objective of the regulation. Of course, this is not a clear aspect. Here you can see some articles in which certified translations are considered as public documents and certified copy. What concerns Article 24, here we have a list of the bodies that are recognized as producing certified translation. So also here we have a parallelism. To conclude, again, we have statistics, as I was saying before. According to our opinion, there is a part which is not much used in terms of potential of the regulation, that is to say, the part concerning private entities. It's clear that the regulation was born as helping what concerns requirements from the member state so that public authorities can formally recognize and accept a document coming from another member state. The regulation was not aiming at private interchange of documents because among private entities, we don't need the legalization. There is more freedom. Of course, that multilingual standards who are released by the public authorities should be accepted also by the public authorities. It's clear that the European Union was born as European Economic Union that should promote the free movement of workers. So today we can't think that a multilingual standard can't be used by employers, cross-border employers who need certain documents to provide their employees certain benefits according to the country in which they are working. Because, for example, in Germany, we have certain benefits. In another state, we have different benefits. So also the private world, the world of employers should use these kind of public documents. As a project, we didn't want to raise awareness on the private sector, but of course, one of the objectives is enhancing the use of the regulation, also showing and highlighting the usefulness in the private sector. I would like to invite you to listen carefully to tomorrow's section on policies, project recommendation and policies recommendation, because in 2024 we will have a report concerning the review clause to have an overview of the current situation and understand how we can improve the regulation. And we hope that also the Council of Ministers and the Commission will also consider our hints. I would like to ask you to subscribe to the newsletter of our website, in which you can get information on documents that are still reviewed and are not published yet. Thank you for your attention.
Vielen Dank. Insbesondere scheint wohl eben geringe Bedeutung hat in der Praxis durch die Länderberichte bestätigt worden zu sein. Jetzt besteht die Möglichkeit, dass Sie Fragen stellen. Den Referenten.
Questions in regard to the country reports or other points that have been presented. If you have a specific interest, then you could discuss it now. Also by the people who are connected online. Are there questions from the audience?
It looks like we have no questions. We are too late. We should go further. So listen now to our next speaker, and we thank our previous speaker.
Von Maria Caterina Baruffi dell'Università di Bergamo.
From the University of Bergamo. Professor Papadopoulou will be the chairman of this session from the University of Thessaloniki.
You're here, and I would like to thank, on the behalf of the organizers, Professor Maria Caterina Baruffi. She holds a PhD and she is a full professor of international law at the University of Bergamo, the law department. She teaches international law and private international law, and the main areas of research cover both European Union law and private and procedural international law. She is also a member of various commissions for the European Union, which makes her a very precious expert for our project. For example, for the expert group on the review of Brussels II regulation, member of the EJN working group on a practice guide to the maintenance regulation, and the expert group on the recognition of parenthood between member states, which is also a very important one. She's also a member of the scientific committee of the journal Rivista di Diritto Internazionale Privato e Processuale and editor of the journal Papers di Diritto Europeo and co-editor of the journal Famiglia e Diritto. Professoressa Baruffi, thank you very much that you are here, and please, you have the floor.
Thank you so much, Chair Lady, for the floor and for my presentation. First of all, I wish to thank you so much, my dear friend and colleague Laura Calafà, for what she's doing for the project, for the outstanding work and the efforts in the development of this successful project. Thank you, Laura. It's a great pleasure to be here with you and with all of the colleagues. And sincerely, thanks to Alexander Schuster, l'anima del progetto in Italian, for the supervision of the project and for the organization of this final conference, jointly with Anuska. In particular, I wish to thank the president Gullini and all the other friends belonging to Anuska and all the staff members. I'm very pleased to be here to this conference and to deliver a keynote speech before such a prestigious audience. It's also an honor for me. My speech regards the circulation of personal status and personal and family status in the EU, the role of public documents. I switched to Italian as agreed, but my PPT presentation is in English. Il primo problema che si incontra con riguardo al tema che mi è stato
we face concerning the topic that I chose, and I thank my friend Alexander for his availability concern the definition of foreign public documents, which is a category in which we have public documents according to the terminology used in the regulation. We have both systemic issues and linguistic issues. The notion of public document is used in Italy to define the category of public records, which are part of Article 2699 concerning notary documents. However, this is not the only meaning of public document. We have three main categories of public documents. That is to say, administrative documents, which is our main focus of today, the Jurister Act, and also the voluntary jurisdiction. Among these kinds of public documents, we also have notary records. This definition allows us to understand the scope of implementation of the regulation 2016-1191, and also the perspective of my speech today. First of all, it's not a case that the regulation doesn't tackle the definition of public record, but the general definition of public document, which is not linked to a traditional classification, which is familiar to Italian people. And this definition can detect the differences present in the different laws, national laws. Moreover, public documents can be referred also to general public documents present in Italy. And they are based on the objective of the attestation enshrined in the article number 2. So that these kind of documents can be released according to Article 3, number 2, by an authority, an official authority. And we have the requirements enshrined in Article 3. We have a public document, and I think that this is also connected to European Union law according to the definition of provided by the European Union. Moreover, we know that the regulation doesn't tackle, and this will also be analyzed by the panelists of these sessions. This doesn't tackle the content of the document, as this notion is connected to the normatives of international law. The objective of the regulation is enhancing free movement of people with documents that are verified by simplifying tools that we mentioned before. From this consideration, I would like to start my speech that aims at providing a consideration on the tools, as Laura Calafa said, of public documents to promote the movement, the free movement of family and civil status within the European Union. This topic is a cross topic concerning sectors that are within the competence of member states, but also it is part of the competencies of the European Union. Therefore, it's not easy to find a balance between justice and national rights. From the European Union perspective, the context is the context of the free movement of people, which is a pillar of the European Union. I think that the free movement of worker is something fully implemented, but it's the free movement of people itself that today is questioned, and that also limits the movement of workforce, because if people cannot fully take advantage of their rights, of course, they cannot move in an easy way. The free movement of people is something important for those studying European law, but it's clear that this is the main pillar on which the European system is based. And of course, we also here have the topic of freedom, safety, and justice, which is present in Article 3 of the Treaty on the European Union. From the free movement of people, we can also develop the possibility to develop family relationships, which are characterized by intersectionality. Clear that the different systems of the European Union are interrelated, so it's clear that we have to talk about transnationality. So we have to guarantee the continuity of juridical situation in which a system, in which a person um, is titular in the origin country. Allowing the free movement of people within the European Union implies the possibility that interpersonal relationships takes place beyond national borders. So the European Union has to act to avoid and reduce the risks of discontinuity in the low life of people. However, the possibility of taking action by the Union is also limited by the lack of competencies to create laws in matters of family law and civil status. These are quite sensitive issues that are within the competence of member states. Of course, these regulations concerns the respective social and cultural tradition.
Le legislazioni nazionali possono costituire un ostacolo alla libertà fondamentali garantite dai trattati.
Of course, that this could represent a hurdle to free movement of people.
Guarantee upon the basis of the primary and secondary law. For this reason, both the union that the Justice Court of Justice, they were called upon to face what has been defined the novelty, the new issues, in order to find the new solutions that could not compromise the fundamental principle of the union, and at the same time without depriving the member states of their room of intervention and also of their identities, and all the norms are protected by the treaty, EU treaty. The Article 81 of the functioning treaty constituted the legal base on which the Union legislate on civil matters, included family law, that since details cross-border implications, jurisdiction, apply law, execution of the decisions issued at the member states of the Union. Moving from the free movement of people on one side and to the cooperation, legal, judicial, civil cooperation, and in particular referring to the family law, I would like to concentrate more on the concrete implementation of the acknowledgement of personal and family status within the member states following the exercise of the free movement, which actually pose in strictly connections the norms of the law, the legal law, and together with the civil status documents, but public documents, and in particular the certificates, do embody a central, pivotal role when we are dealing with the acknowledgement of the status. Therefore, also the rights are coming from free movements, as the Court of Justice asserted since the 90s in its judgment, and where it was stated that the exercise of rights that are deriving from the free movement of the workers is not possible unless the civil status documents are submitted. Therefore, the obligation has been imposed for the authority by the member states to comply, and all the civil status documents that actually are from other member states. Therefore, even if this was an example of application of the theory and the methodology of the acknowledgement that has a French origin, actually, I do believe that we could not really draw a general rule of automatic acknowledgement of the documents on one side of both these aspects. An example is that there is a concrete statement, the implication daily, the civil status officers daily confronted with it. Within the European area, the acknowledgement of public documents, even if it's extremely important, actually is limited, especially if it's compared with relevant regulations of different states. There are new laws that are concentrated on civil status documents. But at this time now we have to make a distinction between those regulations that entails norms that treat the public document as negotium, means under the juridical attestment, or as an instrument. It means that just related to its authenticity, means that is proved that capacity and the also authority who issues the document. So in the first perspective, the negotiations are sectorial documents are considered and based as juridical base, Article 81 of the functioning treaty, but consider this document within the limitation of the application, and which contain norms that consider the acknowledgement of public documents. Generally, they require the production of the very certificates that each of us knows well. But in particular, in within these regulations, three norms, the twins norms, so the 615 2012, 1103, 1104 back to 2016, are those who introduced the terms and new terminologies, namely the acceptance and more than the acknowledgement of the documents, so that these two distinctions can be done. But maybe the regulations that will be applied, and it was hinted before by Giacomo Giaffoni back in Genoa, he was referring to the Bruxelles Terre. It dedicates a lot of attention to this category of document that is extremely important, even if it's limited to the parenthood and divorce. We could um, so we will have novelties in the new and future regulations. Within the second category that I was referring before, means that public document is instrumentum, it falls within our regulation, and it has the aims of easing movement of people and the circulation of documents, and in particular the apostille that is set by the Hague Convention. And as we don't know, all the countries are the contracting countries, and as you know, is far more used as our regulations. And it foresees an easement of the procedure instead of the translations. As you know, the translation is very often very needed, especially. Sorry if I show these annexes, but as I was saying, the regulation is applied only to some public documents, and in particular those who are certain one or more facts, juridical facts, legal facts, that are set in the Article 2, birth, death, wedlock, and so on, and with some limitations, absent of criminal offenses. But in these norms, we have all these facts, and this document must be issued by the member states according to their national laws in order to be submitted in other member states. Therefore, are excluded those documents, uh, public documents, which are issues by a third country, or the authentic copies, the true copies that are issued by a member states. The regulation doesn't change the substantial law as concern the ascertain facts by the member states, as well as the legal effects that relate to the content of the public document that is issued in another country, and therefore with a consonant, for example, that it's a state that is documented by the forms in other country is not necessarily be acknowledged by another country, and in particular if it's contrasting with the very limited that was raised by Schuster. Uh, this means by the public order of the receiving country. Therefore, from this point of view, the sectorial regulation that is called upon by all the regulation that we mentioned, so the private law that we mentioned, have to be considered each time they are applying different fields, especially when the legal effects are considered. So when they are considered as negotium in the public document, the regulation has therefore is very important when we are talking about the scope, the movement of the people, means the application of the life that are set by the documents, the public documents. The aim, even if it's important, is limited to the simplification of the procedure, so that the aim of this legal act, in the sense that the promotion of free circulation, is pretty well explained by the legal norms, by the norms of concerning free movement. There are other legal elements that are quoted in Article 21st, which and this regulation gets outside the civil scope. Um, in the case, it plays a contemporary role. So there are some hurdles concerning the cross-border acceptance of public documents. Actually, impacts very much the freedom of citizens and ignores their quality of life, and enable them, yes, to circulate among the member states without having further hurdles and being on a same level of the citizens of the very country who receives them. So, by legiferating, as we are talking about discrimination, we couldn't but take into consideration the protection of the fundamental rights that is acknowledged by acknowledged by the European Charter. Therefore, the life of some citizens that are very much connected with the application of the regulation enshrined in Article 2, and Article 36 is really the parameter to be considered as we want to apply this regulation. This is the very regulation I was commenting at the beginning. So it's a very important rule. Which are these rights we're referring to? Some of them are rights that are expressly connected to the family scope. They are recalled from the ECHR that, as we do know, has its roots back to the 60s and is actually when we didn't have a group of rights, it was an important reference point. But today, the European ECR chart is extremely important. So protection of the personal data, and also the right to move, to set up a family, or to stay or reside, are all the foundations of our European market. But when we are referring to the Court of Justice, we cannot but comment the role played by the court in this issue. And therefore, it's due to our European Court of Justice that we can say that we have a principle that is the portability of the states. What did the court says? They said on one side, the court on one side highlighted that the circulation of status through transposition of other civil status like affiliation and wedlock falls within the member states' competence. But on the other side, the member states have to, by exercising their competence, they have to comply the European law, and in particularly the free movement of people and the right to reside. So here we can see there is a delicate equilibrium that the states within the internal and the external laws. The rights that are prevailing when except if we have exceptional circumstances, like the identity of to some states in an integrated where we have the member states has covered also the family law.
Volto a tenere separati gli ambiti, i piani.
That the approach of the Court of Justice want to separate different sectors. From the one hand, the free movement right and the hurdles connected to the lack of the exercise of family and civil status. From the other hand, the recognition of the substantial rights beside this status. So, of course, we have to recognize the status imposed by the jurisdiction of the court to the state, which is functional with the objective of guaranteeing the right of free movement. This is also clear from the last judgment of the Court of Justice of the 14th of December 2021 on the Pancharevo case, in which the Court of Justice was called to decide on the issue of parenting of a same-sex couple. Of course, this is a always more frequent issue, but always very much sensitive, especially for this reason, particularly sensitive, because the member states have exclusive competencies and we have relevant differences within their national laws. The court based its own reasoning on the extension of the possibility of using Article 21, that is to say, free movement, and also of the right deriving from primary law for the implementation of directive concerning citizens' rights, that is to say, Directive 2004 number 38, also to those who never took advantage of the free movement and staying in a state which is different from the origin state. Especially because this state is different from the one when this person was born. The people who took advantage of this right were the parents of this person. So first of all, we have the obligation to release to this person an identity document or a passport in which there is a surname, a citizenship, always base the decisions on the public document of the member state different from the origin state. So considering the two mothers as mothers, even though the national system doesn't foresee that, without issuing another birth certificate. Other than that, we would undermine the right of the minor to freely move with each one of the parents that are reported in the birth certificate. A member state cannot invoke its own national right to superpose age to an existing birth certificate. Of course, we also have here the common case on the free movement of same-sex couples. However, as the court has said concerning common case, we don't have an obligation for the member to introduce law institutions which are useful to use the status acquired in another state or member which are not recognized within that state, but still they have to guarantee the enjoyment of rights coming from the union law. So, of course, the recognition of status is functional to the use of the, the enjoyment of rights. So, the court has found a solution that allows the free movement of identity documents that are present on the birth certificate, in this case, that was issued in Spain. However, also considering the rights of minors, the legislative process did not stop and is going on to give a more effective solution, to provide a more effective solution to provide the right of being son through a specific directive concerning parenting that adopts the proposal of regulation within the third trimester of this year, that S is a law-based Article 81, so a regulation from the international private law, to put in place the decisions in the field of parenting, which is a topic on which the union has no competence. It's clear that the union could close the gap, the existing gap, overcoming the limits of our regulation. However, it could also face many difficulties linked to the fact that every member state must vote in favor of this regulation, because Article 81 asks for unanimity of member states. For these reasons, maybe it could be useful going on having a debate on a different legislative action, always based on the free movement of people, with the aim of issuing a European certificate, a sort of identity card that guarantees the fundamental rights of the minor as enshrined in the fundamental charter of the European Union, to guarantee free movement of people. So, to take advantage of the rights that are guaranteed by the treaty. The certificate could be released after a request of the parent or of the subject according to standard models, without undermining the recognition of the family status where this in the states where this certificate is presented. We would stay within the competence of the European Union, and the state in which this certificate is presented would be obliged to guarantee these kind of rights to European citizens who take advantage of the member state in the state in which the authority that released the certificate is present. This is something less compared to the ideas of the Commission, but on the basis of the norms of the Charter, Article 7 and Article 24, we could highlight the interests of the minor that should be considered to verify if there are limits to free movement. This would imply the benefits of the minor, of the right to have a free movement directly when the minor is a citizen of the European Union, or indirectly when we are tackling with a extra EU citizen that has a family relationship with an European citizen. And trying to imagine from a practical point of view the content of this European certificate, we could think about standard forms also based on those that are attached to the EU Regulation 2016/1191, and also on the perspective of the registers using the information present in the birth certificate of the minor. In this way, we would recognize the parenting relationship, even if just to guarantee the free movement of people and the connected rights without undermining the recognition of the clinical effect of this status. Of course, this would be a step forward compared to the regulation that is limited to administrative cooperation. This would be a legislative action that would eliminate discretionality of the competent authorities, that would be obliged to respect the judgments of the European Court of Justice, but it would also avoid the lack of consensus of member states. So common panterever, we would have a regulation or a certificate. I don't know. What I can say is that the topic of free movement of status within the Union oblige us to find juridical solution that, even if complex, are based on the effectiveness of the right protection. So of course, regulation can be good, but this member states have to accept that, and we are not certain of that. Thanks a lot.
We thank you very much, Professoressa Baruffi, for this excellent presentation of all the relevant issues and the newest developments on European Union law. Would you accept some questions if there are? Of course. And I spoke a lot because I don't want to answer to the question, but yes. If you have, I'm here. If there are some questions, purpose. Feel free. Yes, please. Please introduce yourself, and then you can.
Frau Präsidentin, wenn Sie gestatten, möchte ich gerne Ihnen.
You mentioned the decision of the European Court. Okay.
Use to make a new certificate of birth after a child is born. So that is completely contrary to what you told, that a child must know has a right to know his identity.
Right. You are not, the states are not obliged to issue another certificate. If they want, they can do it, but they are not obliged, in particular when they have problems in relation to a totally different legislation, national legislation. What the court said is that all the states are obliged to recognize the status, the personal status, in relation, in accordance with the certificate of the state in which it is issued. That's it. But if the Poland or the Czech Republic or Bulgaria, Bulgaria if they want to issue another certificate in accordance to the original one, they can do it. The problem is that they are obliged to respect the status in the personal status of the original documents. My pleasure.
Thank you for the question. Any more questions? Okay, I think there are no more questions, but rather the pleasure of coffee waiting for us. Thank you very much once again.
Thank you, Chair Lady.
Oops. Before we break for the coffee, we had very large coffee breaks, so we'll have 20 minutes, which is still enough. After the coffee break, there are two parallel sessions. So either you come here, that's the plenary room, okay, or we have the first parallel session in the Sky Hall or Sala Cielo, and that's over there. So you go to the hotel reception, step out of the reception, turn left, you'll see Sky Hall Sala Cielo, and that's the first floor in the building near to the hotel.
Hello? Okay. Hello? Thanks. Welcome back after a longer break. I think we can start with session A. It's my pleasure introducing the first panel of this afternoon. We're speaking about the concept of identity across time, space, and case law. And I'm very happy about the presenters. I'm going to introduce them really quickly. We're going to start with Professor Shakargi. She's a senior lecturer at associate professor at the Faculty of Law at the Hebrew University of Jerusalem. She specialized in private international law, family law, and comparative law. And in her works, she studies legal manifestations of identity and of how they changed over time. And that's also a topic that we'll be focusing on right now. Professor Shakargi will be speaking about the concept of unidentifying identification, and I think we can start now. Thank you.
So thank you, Paul. Thanks to the organizers and to you for being here. Okay. So I want to start by putting the question of, can a mere unassuming regulation solve the issue of modern cross-border legal identity? At first glance, it appears that the regulation that we're discussing, 2016/1191, aims to do just that. It creates a mechanism to quickly and easily mutually recognize several identity items such as birth, name, marital status, parenthood, residence, and nationality. The aggregation of these items, each item by itself doesn't seem much, but together they are what is in close approximation to what is generally seen as one's legal identity. So if the regulation can indeed regulate all of this, then it has done a huge thing. But I'm not sure it does. So I want to try to offer three critiques towards the regulation. The first one would be that it omits some essential components that should be in it if it aims to create a legal identity document. The second, that it includes some components which are arguably irrelevant, though I understand why it does so, but still I will put this criticism on the table. And the third, that it might be, I'm trying to be careful here, but after Professor Baoufi's lecture, I think I can say that it might be ineffective, since it does not deal with the substantive transference of identity, which is a highly debated issue. So before we delve into details, and again, Professor Baoufi's introduction to my paper was extensive, so I will make it brief. But before delving into details, let's start by discussing the relationship between the regulation and free movement. So as we know, the free movement is a driving force in the regulation. Identity has immense personal importance. So to me, my identity is very important, but it is not just important to me. It is also important to the states, other bodies. So just think, it's a critical tool for unlocking rights in our world, which is why identity is so important. And it is used in everyday life. So just think of how many times you had to use your identity to get here, right? I had to take a plane, so I had to present my passport. Then you have to take a train, and maybe you have to show identification to show your nationality or age. Or if you rent a car, you have to show your driver's license. You check into a hotel, again, you have to show some sort of identification. So you had to do all kinds of things all the time, identifying yourself as if it's nothing, but you did do that with legal documents. This only becomes much bigger and much more crucial when you try to actually move somewhere, right? So you have to buy or rent an apartment. You have to make your driver's license valid, because international licenses are valid only for such a certain amount of time. To be able to work, you have to have them recognize your profession. So if you're a lawyer and you have a diploma for one country and needed to be recognized in another country, you have to be able to register your children to school. So you have to first be recognized as the parent, and the names have to be right, and everything else has to be right for you to be able to do this. Your marital status might have to be recognized for your spouse to be on your medical insurance. So a lot of things that are related to identity are everyday problems. So it is evident that an easy transference of identity is a crucial part of actual free movement. You can't really move between countries without your identity moving with you. So if it's very difficult to move your identity, you can say that you have free movement, but you really don't. So since free movement is one of the most fundamental goals of the EU, like as mentioned in the previous lecture, it is not surprising that the EU aims to regulate the free movement of legal identity, and the regulation is an attempt to do so. So the EU has already created some mechanisms to regulate the transference of professional licenses, for example. So for being a lawyer or being a doctor, that is already recognized, but it has thus far not offered a mechanism for transferring the parts of legal identities which are covered here. The regulation is this. The regulation tries to move legal identity between borders, but and though it doesn't say so, it is the closest thing there will be, I think, to EU identification cards. So state union-wide identification card. But the reason there wasn't an identification card in the EU so far is, I think, maybe the reason why the regulation is problematic or achieves less than it maybe aims to do. So let's start with the omissions. If the regulation aims to correctly transfer identity, it is surprising that it only does so partially. So if this is my identity card, it should include my entire legal identity, everything that is relevant to my identity. So some of the omissions that I would expect the regulation to include are sex, for example. Sex is a legal category that is relevant to many rights. And it is part of people's legal identity. In some countries, religion is also part of their legal identity. So your religious group actually says something about taxes you pay or money that is given for you to the church. It might influence your marriage and divorce rights and other things. And there are other examples as well. So the regulation does not cater for the transference of these components, even though they are, I think, parts of legal identity. This might be due to several reasons. First, it might seem that those items of identity are irrelevant. And with sex, for example, with religion, some states already made religion irrelevant. With sex, there is now a push to make it irrelevant. So people want to be self-identifying their gender, and some people mix that with sex, and they think that there shouldn't be a category of rights that relates to your sex. But this argument is difficult to substantiate, because it's enough that some jurisdictions within the EU do have rules that are different for men and women. So it's enough, for example, that if you're a woman, you get a different retirement age than a man anywhere in the EU for this to be relevant to the European legal identity, or maternity rights, or military service that is different when there is military service, or any other thing that might be different between men and women. So as long as there is such a rule in one of the states of the union, then this omission is problematic, because this part of your identity, of your personal identity, is actually a part of your legal identity. And the same goes for legal capacity. So if you're a minor or not, and if you're able to act freely or you need any protection. And the same, as I mentioned, is right for religion. So this is the first explanation. The second explanation might be that the EU legislator is aware that this is still a relevant fact of identity, but opposes it. So the EU legislator might want to say, yes, I know religion makes a difference, but I don't want it to make a difference, so I'm ignoring it. Such a reading would argue that the EU legislature wishes to put forward a more modern and more advanced position regarding legal identity, and it wishes to marginalize things that are irrelevant. So even though some states think sex is relevant, the EU legislator might wish to marginalize it. But if this is the case, it seems the regulation is over-inclusive and that other components of identity should also not be included, and I will delve into this a bit later. A final explanation might be that issues such as sex are highly contentious. So the issue of trans people is very is in hot debate in some countries, similarly to the issue of surrogacy, parenthood, and surrogacy. And so it might be that the EU was practical in saying, let's leave it aside because this is too complicated for us to deal with this. But the problem is that if this is the argument, then it seems again that the regulation is over-inclusive, right? Items such as marriage, parenthood, and even names might also be A, debated, and B, contentious. So it's problematic, right? So for some states in the EU, saying that there is such a thing as same-sex couple is offensive, and in other countries saying that there isn't is offensive. So if you want to not offend anybody, first off, you can't make you can't make a cake without breaking eggs. So you have to offend someone to get somewhere in life sometimes. So the regulation would be meaningless if it wishes not to be offensive. That's the first thing. And second, it is already offensive. So why not offend some more? So it is hard to explain the distinction between what is included and what is not included in the regulation. So I discussed omissions. Now I want to move fully to discuss inclusions. So some parts of the regulation I think are over inclusion. As mentioned before, the regulation might reflect an effort to draw legal identity more accurately, so only to include what is crucial, and justifiable to legal identity. This could have been an important statement, a big theoretical work that takes now real life action. And this could have made the regulation a novel and brave legal document. But this does not seem to be the case. And it's not only because of the understated nature of the regulation. So you can write a quiet document and make a revolution, but I think this quiet document does not make a revolution in this sense. The discussion before alludes to an assumption that things might become or cease to be relevant to one's legal identity. Like I mentioned, sex is under debate now. Religion is, under some countries, no longer part of legal identity. One easy way to elucidate this point is through the notion of legal status. So in traditional jurisprudence, jurisprudence literature, there is a lively debate over the exact definition of status. Austin even said that this is the most difficult definition in jurisprudence. But for our discussion, it is enough to say that status is a tool that distinguishes between groups of people based on rights and duties, or rights and duties and capacities and incapacities. But it has to be a significant change. So if by being a member of this group, you have a different set of rules and norms that apply to you, this would be a matter of status. Sex is a matter of status in the sense, as I mentioned before, that it creates groups of people that are different in rights and duties, capacities and incapacities. Maybe less so than in the past, but it still does that. Because male and females are distinct from each other in significant ways. It might be argued, and indeed I argue in another paper that I'm writing, that the changing attitude towards sex in law might result in sex no longer being a legal status, so no longer being a relevant category of legal identity. But this is not yet the case. So for now, sex is still, in many countries, still a matter of legal identity. A more pressing or more convincing, I think, example is marriage. Marriage used to be the status. So capital S status in books would be marriage, right? Because marriage created a group of people who are, so married people are distinct from single people in their rights, duties, capacities. The law governed who can marry, whom you can marry, what will be the content of your marriage. It also made sure that you can't get the same results in any other way. So there weren't contractual relationships that could imitate marriage. This has changed. And so I argue, again, in another paper, that marriage is no longer a matter of status. Nobody likes this argument, but I think it is still true. So if the regulation intended to be very accurate and very up-to-date in its approach to identity, it maybe could have left sex out. It is right to leave religion out, maybe, but it should have also left marriage out, which it didn't. So the omission and the inclusion don't work together. I don't find an overarching explanation for both of them. And now I get to my third point, which is the ineffectiveness of the regulation or argued ineffectiveness. So the regulation does not only overreach and underreach in the items it regulates, but it also, I'm trying to be kind here, but I think what it doesn't do well enough. And here is why. Um, the regulation creates a mechanism for direct and mutual recognition of identity components. So I have a name in a document, I give it to another country, that country has to believe this is my name. It has to register it. For another example, I was born, I have a document, I will show the document, and here is the fact of my birth. The mere fact of my birth should be recognized between states. You can read the fact of birth more broadly. You can say that it also says who was born, so man or male or female, and you can say to whom, so deciding the parents. But if the regulation only means birth, the fact, then that is easily transferable. Um, and I think the regulation aims to do just the fact, so it steers clear from the more problematic aspects. Um, so the very basic fact of birth is indeed transferable, but some questions are less factual and more law-based, so based on law. While the regulation aims to allow for the transference of, for example, one's marital status, um, marital or spouses, because it's also other unions, um, it is evident that the substantive validity of a relationship or its dissolution is not merely a matter of registration, but rather a matter of complex private international law questions, which is exactly what Professor Baoufi discussed. Professor Baoufi thought that the solution would be that the EU forces states to recognize something that another state did for free movement. But insofar that this is the law, then there is no problem. But this is very problematic, and I doubt states will love this interpretation. So, and indeed, many of the questions in the regulation are actually regulated through other EU regulations. So, for example, the Brussels 2 bis recast and the Rome 3. So you could have assumed that the answer would be anyway the same between two member states, and there's no problem. So if I have a French decree from state A that was created through Rome 3 and Brussels 2 bis recast, then I could assume that Germany would anyway get to the same answer. But this is not the case, because different countries interpret differently and apply different laws and get to different outcomes. So I can't assume that another states will get to the same answer. Further, there are many cases where there are not EU legislation to regulate the matter. So one example is names. Both the name itself and its spelling, like we've discussed in the break, is a matter of legal identity, but it is also a matter of debate between countries. So consider, for example, the Garcia-Ovella case, Garcia-Ovella, where Belgium and Spain could not agree on someone's name. So if the regulation aims to solve this problem, then it can't do it just so quickly and easily, because this is a highly debated issue. So can another state force me to lose my name? Or maybe can I force a state to recognize a name that it is not willing to recognize? And there were cases, there were a lot of case law, both about spelling of names, which is different between countries, and about the actual name. So how do you compose the name? The regulation should, on its face, allow families such as the people like Garcia-Ovella or families who want to register their children, it should allow them to just present the document and have them be registered in another state. But if the other state of destination, disputes the name registered, how would that be of use? So they will just not be, either they will not be willing to register, or they will register, but then they say, but this is meaningless. So it is not very helpful. The same is true for surrogacy cases, where states are pushing back all the time that they don't want to recognize, and the EU courts, there's a backlash, but the debate is still going on. So to conclude, all of this does not go to say that the regulation is meaningless. I was critical, but I think this is it still does some things, and it is a very good thing to be done, and it's also a very important discussion to have, that we should have. Items that are included in the regulation and that are registered in member state A in a manner that does not bother member state B are transferable, and that is great. But the gap between this modest outcome and the actual free movement with which the union is committed to is significant. While the regulation might allow foregoing apostille and directly transferring various legal documents, it might not allow foregoing extensive legal proceedings in order to transfer the content of said documents. So that just the document isn't it. This outcome, as well as the over and under inclusion of the regulation, are understandable. The topics covered by the notion of legal identity are the most sensitive, debatable, and contentious. States hold their preferences and beliefs in those issues in high regard and are often unwilling to negotiate and compromise. When it comes to these questions, we can understand why they are not willing to compromise. Yeah? Um, Achieving consensus over matters of personal identity is not an easy thing to do. However, protecting identities on the move still has a long way to go, even in the aftermath of the regulation. So the regulation is a first important step, catering to straightforward questions and cases, but the more complex and in-depth measures are needed in order to allow for the real freedom of movement for which we strive. Thank you.
Thank you. Thank you, Sharon, for your interesting presentation. I think also provoking at certain points. I think if someone has questions from the audience, they're free to, or comments. Yeah, please.
I am Rob van der Velde from the Netherlands, and I'm a central authority. Professor Shakari, I don't want to be rude, but I completely not agree with your statement over here. Because I think the regulation is not to create an identity. The regulation is to help member states to get their forms accepted in another member state. So I think you are completely beside the lines. For example, if I send a document of same-sex marriage to Poland, to my neighbor over here, it's their decision if they accept it. And the regulation or not, translation form or not, does not interfere with their decision. So I think it's not about creating an identity, it's about helping to get an identity created. And that is a very substantial difference within your speech. So I wanted to state it. I fully disagree with you. I think it's very important. There is no thinking, no any misunderstanding between you and me. But I think the regulation is not about creating; it's about helping.
Can I answer? I don't think we have a debate because I agree that this is about transferring. But when you transfer, you create something in the state of destination. Yeah. So I'm not saying this is creating. You create it in your home, but when you transfer it to another country, then there is now something new happen in the country of destination. And to this, as you say, the regulation does not help, which is what I said, because Poland can say, I do not agree. And then, so what did the regulation do here?
Well, I think with your activism, if I may say it so, you must be very careful, but because the Polish government could say, well, go not farther. I think you must be positive about the regulation, but to put it in a very active way, as you did it over here, I should be very hesitating in that. Please take care of what you are saying, because this was very provoking. In Holland, it doesn't matter, and we see each other as a guide country, not also good every time, but please take care. I don't think that it helps the regulation if this if we are saying all these things in the same way. Please take a little hesitation.
Thank you. Maybe if you want to comment. I mean, I think we know that the regulation does not apply to the recognition of the content of the public document itself, which also connects to the scope as you discussed. I mean, I've been part of a seminar last week actually, and there one participant stated that the facts established by the documents that are covered by the regulation actually are just a test balloon so far. The Union and also the European Union wanted to try out certain facts maybe, and also motivated by certain practical aspects such as establishing certain infrastructures. For example, the IMI had to include certain forms and examples of public documents. So I think there is a lot of room to get more identification documents or more civil status document within the scope of application. What is interesting, also, I think that is just a comment, is that you said that these facts establish identity, and at the same time, the regulation in its recital 10 states that it does not apply to identity documents themselves. So, which is just some interesting comment I found. Are there some other questions? Yeah, Professor Papadopoulou?
Excuse me, if I understood you correctly, you said that it is an over-inclusion, that the regulation refers to marriage, and you proposed that it should better leave marriage out. Could you please elaborate on that? Why do you propose that?
So I was trying to, I'm not saying the regulation should leave marriage out. I'm saying that for it to be consistent, if there is no sex in the regulation, I don't understand why there is marriage. Because a different project of mine, I discussed the question of whether marriage is still a matter of status. And I think it is not. I know it is very debated, but I think it is not, because because now it is much. So it used to be that the law regulated very, very in detail whom can marry, whom you can marry, what will be the terms, what will be the content of the marriage, and how, if you can exit, how you exit, and that there is no alternative to marriage. But now, so first of all, and the easiest thing is that there is easy alternative to marriage through civil unions. The laws are, if you do a historical comparative survey, which I did, you can see that it's becoming very, very lenient. It tells you much less about whom to marry and how to marry and what the marriage will mean to you. And since you can get the same or almost the same, in many countries, almost the same outcomes without even being married, that I'm not sure marriage is a status. I'm not saying the regulation should take out marriage. My work is only to offer a critical view for people to think about it. I'm not saying the regulation is good or bad or anything like that. I'm just saying that if this is in, this should be in. If this is out, this should be out, just to be consistent. I have no position on which one you should choose.
Are there some more questions? No? Then thank you again for your presentation. And I think we can move on to the second presentation of Professor Cristina Campiglio, who will be speaking about the recognition of civil status records in the aftermath of Regulation EU 2016-1191 on public documents, a new functional identity for EU citizens. Let me present the next speaker.
Grazie a tutti. Chiedo se possiamo condividere.
I would like to ask if we can share the slides. We are trying to share the slides now. Thank you. Just a brief introduction.
Law, international organizations, and the protection of fundamental rights and freedoms. She is a co-director of the reviews of Diritto Internazionale Privato e Processuale and Diritti Umani e Diritto Internazionale, and a co-author of a very famous Italian handbook called Diritto Internazionale Privato e Processuale. And I'm very happy to hear what she will have to say to us. Thank you. The floor is yours.
Grazie a voi per l'invito.
For inviting me. I would like to give you an overview about the regulation. And I will also talk about the functional identity of EU citizens. Also based on what the previous speaker said. We can move on to the next slide, please. I would like to read an extract of a document of the Commission. A citizen of a member state is also citizens of the European Union. The citizenship of European Union gives every citizen of the Union a set of added rights. However, there is still a gap between applicable normatives and daily reality. Married couples in the European Union are all more or less 120 million, and 60 million of them have a cross-border dimension. For citizens who move to different member states, it's fundamental to have a recognition of civil status record, for example, concerning birth. They can also vary within the European Union with consequent issues for recognition. Citizens are thus obliged to meet long and expensive requirements that can also undermine their exercise of rights.
Europea nel 2010 in un rapporto
Tool that allowed EU citizens to have a recognition of their civil statute documents. The European Commission so presented a Green Book whose topic was less administrative requirement for citizens, promoting the free movement of public documents and the recognition of the effects of civil status record. To overcome the hurdles to the free movement of citizens, the Commission established the abolition of administrative formalities, the cooperation among national authorities, and the limitation of translation of documents. And on the other hand, which is most interesting, the introduction of a EU civil status certificate based, for example, on driving licenses and EU passports. The idea was to offer EU citizens the possibility to ask for the release of a EU civil status certificate together with the national civil status certificate. However, and this is the most interesting part of the Green Book, the Commission reported the need of guaranteeing the continuity and the permanence of the situation of civil status.
il regolamento 2200 del regolamento, l'automatico aggiornamento delle iscrizioni
So after the divorce or separation decision of spouses that was pronounced in another member state, was also recognized in different member states. What concerns the way to recognize the recognition of these effects, as of course it was not possible for the European Union to change national laws what concerns family laws, the Commission proposed three solutions. First of all, assisting national authorities in the research of practical solutions. Secondly, recognizing the full right of a member state of civil settled situation that were created in another member state. Thirdly, the third solution was promoting the mutual recognition through the harmonization of international private laws normatives, that is to say, creating common normatives on the applicable law. For example, as already exists in terms of food policies and contractual policies. However, this last option would have need compensative measures to avoid situations of fraud and abuse, to respect the public order principles, which are the fundamental principles of national system, especially what concerns marriage. And this is linked to what said the previous speaker. After a public consultation, however, the Commission reduced the scope of application of the laws and back in 2013 proposed a draft aimed at promoting the free movement of citizens and enterprises, simplifying the acceptance of documents. So we went from recognition to mere acceptance of documents. The proposal wanted to avoid the presence of formalities, simplifying formalities connected to authentic couples, and to overcome linguistic barriers. They implemented multilingual forms. The text didn't focus on the recognition of the document because the standard forms just had a proof value as national forms. What concerns doubts on the authenticity of these forms, as we said before, authorities can ask for information to the authorities of the source of the origin state through the IMI system or directly contacting the central authorities of the member state. On the 6th July 2016, the European Union released the regulation 2016-1191. So we went from recognition to acceptance to the mere presentation of public documents. So from the title, we understand that the expectations of some year before are not met. So we don't talk about the recognition document, and we don't want to change the rights of member states because this is not feasible, of course. So this regulation, as we already said, exempt from legalization and introduces a system of administrative cooperation based on the IMI system. This is a system that is not present neither in regulation exempting from legalization, for example, the judgments, nor in the regulation that focuses on the registries connected to insolvency procedures. For example, these registers are interconnected to promote the circulation of data. A good idea would be the creation of an interconnecting network of civil status registries This would mean that in each member state, these registries are digitalized, and that these kind of information are part of a centralized database. Actually, we already have a platform for the communication of civil status information. It also benefits from a co-financing by the European Union. This is the platform created by Convention 33 back in 2012 of the ICCS. So, for example, it would have been possible to promote the movement of these multilingual forms to use this platform. This was not possible because the multilingual forms are not the same of the multilingual standard forms of the ICCS. Let's move on to the next slide, please. The Sorry, please go back to the previous slide. Can we please go back to the previous slide? Thank you. So we welcome the regulation because it introduced common rules for the free movement of documents. As we have already emphasized, the European Union is based on procedures. So it doesn't share the main idea of the Commission back in 2010. Of course, the regulation is still based on the difference between the instrumentum and of the negotium. The regulation is based on the instrumentum, on the tool. And this happens because the regulation of family documents is really hard, especially when we talk about marriage or same-sex unions. And we already were aware of this omission. The evaluation of the presence of this situation, so of the family relationship, is still in the competence of member state, and each member state has its own national private rules, private laws. So the impact of the regulation of 2016 on the mobility of EU citizens is just reflected.
It's a pragmatic approach. So it's needed to lower bureaucracy and reduce the costs. So it's approachable, but itself doesn't enable the circulation. But on this point, the Court of Justice intervened and started a praxis that, as we will see, shows also some shadows. If we could move and skip to the next slide, please. Thank you. The case law of the Court of Justice in the last years has taken over a technique which it started working on in the 70s of last century in the matter of economics. And it's about the mutual recognition. In the 70s, it was about the ware and the services. And the Court of Justice has started considering the normatives of the member states, so the production of the state, of the ware and the destination of the ware as equivalent. So the production state was able to circulate in all member states because the normative foresaw this. Starting from the 2000, this technique was used by the Court of Justice, also a matter of circulation of the people, not just of the goods and services. And this was extended first to the right of name, but more recently to the right of family in order to enable the citizens of the Union and their families to go around and to stay in the member states as foreseen by normative 28 of 2014. We need to understand who the family members are. The first complex thing which came up is the word spouse. In the common case in 2018, the court says that it's neutral from a gender point of view. So it's referred to the spouse of the same sex as well. The case was about a Romanian citizen who had married a US citizen and wanted to come back with the spouse to Romania. In Romania, the same gender marriage is not possible, so this marriage didn't want to be accepted, but the court says only for staying in a certain country, the same-sex marriage needs to be recognized. The other concept is the direct descendant. All this is in the same directive. In 2019, the court says that a direct descendant is also the adopted child, but not the child who has been taken from fostering. And also the child of two mothers, as for the last case, I cite the court. The child is also the minor whose birth certificate released by a member state, in this case, one of the spouse, who represents two parents, two same-sex people, and one of them is a union member citizen. This has to be considered legal independently from where one of the two spouses comes from, and it's not needed to release a new birth certificate. We can move to the next slide. Thank you. The result of this case law is that a personal identity, which is functional only to the rights which come primarily from the European Union, so also from the functioning of the European Union. The circulation of this state is possible when this comes from a civil act, which does not produce any effects on the recognition. So the instrument implements the status which is inside the document, and this status is used to say that there is a continuity towards this status in all member states. Trust in both sides and equivalence by the public administrations is the principle of this. what we saw before was about the legislations about goods and services, but now we're talking about people and personal identities as something which is much more delicate and which has to do more with the rights of the person. Let's skip to the next slide. The idea of establishing a European certificate in the field of family is not over, because the Commission is evaluating the institution of an European genitor certificate. The pathway has begun towards a regulation for using the law in terms of genitoriality. So this way the legislations come again. The public consultation ended in August of last year, so the Commission is now working and is evaluating the creation of this genitor European certificate, which is optional as the other certificate which was created in 2012. And we now need to see whether the certificate can freely circulate without any checks, or whether it's possible for the destination country on the national principles. Come to the next slide, which is also the final one. What is the conclusion? The conclusion is that the regulation of 2016, from a practical point of view, has left a gap behind concerning the recognition of civil state certificates, which was also confirmed by the Court of Justice. The Court of Justice is working on granting continuity over the borders. This continuity, however, operates from the rights which come from the European Union. It does not, this continuity does not operate in the perspective of other rights, the rights which are recognized by the member states, by the national legislations of private law, the topic of responsibility, or other kinds of rights. So the citizen who goes around Europe is checked by the national states. So we have a personal identity, which is a full identity, which continues being checked and constrained to controls because of the differences between the member states. And then we have a European identity, which goes around, and the citizen of the European Union goes around without any checks, but is also useful for the circulation and for staying permits. What is the consequence? This is becoming a paradox, because within a single country, let's take Romania, for example, the two spouses of the same sex, as long as they circulate and staying permit, they are considered married, but not for other rights. So it exists sometimes, but not in other occasions. Many years ago, this was the case for a person who was married in a single country and not in a second country. But here we have a different case, and it is a paradox, because we have the same situation in within the same country, because we started by talking about identity. So I would like to ask you, isn't the personal identity the projection, the social projection of the personality of an individual in its uniqueness? My identity is my uniqueness, but in reality, what we are seeing is something completely different. And the citizen of the European Union doesn't have a unique identity, but has a double identity. And I think this can cause practical problems, but also some doubts as for the conformity to the chart of the fundamental rights of the European Union and the human rights when we talk about right to personal identity. Thank you for your attention. The presentation, thank you.
Right now, and I think there might be some questions also from the audience. If not, maybe I can break the ice with a brief comment. I think, if I'm not mistaken, you also mentioned the Pancharevo case, and it is interesting, as you said, that the European Court of Justice only obliged member states to recognize the to recognize parentage for the purposes of free movement. But at some point, as is, if I'm not mistaken, in the judgment, it also states that the free movement is also closely connected to the exercise of the right of, or to the right to a private life. So it is a question also in the Komen case to what this extends to. So one might argue that exercising one's right to free movement may not be enough in order to exercise your right to private life. That might contain also other aspects of one's person.
I casi sono due, o la Corte di Giustizia.
The cases are two. Either the Court of Justice realizes this, there is also another analog case. Either the Court of Justice realizes that something is wrong and it changes, but I don't know. Or the only thing that I see is that would be a huge step that the court says that the recognition has to be a full recognition. This is what the Commission wanted to do before. Here we have the problem of, well, currently the court is saying that these cases, these situations can also be against the public order, but it's important that they're not against the national identity. So say, okay, you, Romania, are not obliged to introduce same-sex marriage. You just need to recognize it due to circulation. And not recognizing has nothing to do with your national identity. So, public order and national identity is something different. We need to understand what the Court of Justice would do. I had some debates with an ex-lawyer of the Court of Justice, or with the next judge, and he thinks that the court is not doing these steps. So we remain in this limbo, in this situation. I don't know if you agree.
As to extend the concept, it won't do it. So I think for now, and also in the pending case, we will have a similar result. But we have to mention that the national court, actually in the Pancharevo case, obligated its national authorities to recognize parentage, not only for the exercise of the right of free movement, but also to issue a birth certificate. So it went further, even further than it would have had to, according to the European
Sì, però
Court.
poi la Corte ha detto che non è necessario.
No, exactly, but then...
Perché basta...
yeah.
Quindi...
Yeah. Are there other questions? If we don't have any other questions, thank you again for your interesting presentation. We will move on to the next presentation now. So we have here with us today Claudia Elena Marinica. She wrote a paper about the case law of the European Court of Justice and the effects of free movement on persons and public documents. And Professor Marinica is an assistant professor at the Faculty of Public Administration in the Department of Law at the National University of Political Studies and Public Administration, and holds a PhD in Administrative Sciences. And she will now present her paper.
Thank you. It's okay. Okay. Hello, everyone. Okay, it's better? No? Okay. So, the research was based on some case law presented before by Professor Campiglio and also Professor Baruffi. Is focusing the research. If you see it, I first made an analysis. The research is bigger, but I will try to point some interesting ideas. It starts from the analysis and reflection of the European Union level and the national level in Romania, and is focusing on the case law of the European Court of Justice related to the scope of the EU regulation in cases concerning citizenship and a number of family law issues that have a direct impact on public documents and the free movement of persons, without bringing any prejudice to the national identity or public policy of the member state. That was what Professor Campiglio said before. So, to what extent Regulation 1191 ensures progress in the circulation of certain public documents is one of the first question I try to answer, and I will point to Romanian perception here. And another question concerns the European case law of Court of Justice and European Court of Human Rights, whether and to what extent this has an effect on the free movement of persons and certain public documents. For the first aspect is that to point out that the history of the right of free movement starts with the Treaty of Paris till nowadays, and is linked to the European citizenship, family matters. If you see that civil events taking place in the life of a citizen, including free movement of public documents. So the Court of Justice is the main actor in the legal system of the EU, a remarkable interpretative authority, making an important contribution to the standardization of the European law. We all know that through their interpretation, the Court of Justice and the European Court of Human Rights ensure the mobility of the citizen of the European Union, an European Union based on the protection of fundamental rights and freedoms, in which the personal status of the citizen is a competence belonging to the member state. So, as Professor Campiglio said before, in Romania, Romania only recognized the marriage between a woman and a man. So, if we refer to the case law of European Court of Justice or European Court of Human Rights, because all the states that are members to the European Union are also members of the Council of Europe. That's why I put the European Court of Human Rights here in discussion. We can see that, sorry, we can see that family life and not necessarily the institution of family is the one that should be the subject of all concerns. Changing the classic concept of marriage, even if the European Convention on Human Rights does not impose on states the obligation to allow access to marriage for same sex couples. So, the rules of national law governing such areas will become insufficient in relation to the complexity of certain cases, and then the Pancharevo case is one of this. And it will be much more of this because I'm sure that it is not a singular case. Uh, also in Romania, I asked myself if one of the parents in the Pancharevo case it would be Romanian. It would be the same as in Bulgaria. So I tried to figure out, as Professor Campilio said, it is enough. It could be something more to do. Um, the European law does apply, but national law it has an important voice. So changing the legislation in a Romanian case, it could be a solution because uh, acting or requiring from an judge to give a solution to recognize an affiliation of a child is a temporary solution. It is not the definitive solution because this is a administrative procedure that only a judge can resolve. And after that, without a transcription of the affiliation, so in the end, changing the legislation, it might appear as a solution. So I will move forward if it's okay, because I will try to point out some ideas on the free movement of certain public documents within the European Union and Romania's perception. First of all, the first part of the analysis is connected to its essential theoretical aspect introduced and with the practical ones, pointing out some aspects regarding its perception in Romania. So, Romania has always shown reluctance on the part of both citizen and state authorities to address their issues. In reality, it is a tool not very well known in Romania because perhaps it has a relatively limited scope, but also because of the reluctance of citizens and institutions to apply this simplification of procedures and to ensure a free movement of public documents. When people um, are going to another state, they want to be sure that all their public documents are safe, are having all the procedures made, and are not they are not obliged somehow to return in the state country to do another procedure or formalities. That's why also before the regulation, if there was a convention, a treaty between Romania and another state which do not impose an apostille, for example, there are persons, citizens, who um, tried to have one just for their safety, not for the other reason. So this regulation is in the same position. Um, that's why in Romania, for the moment, Regulation 1191 is not a major topic discussed in the literature, although it has attracted the attention of public authorities. And when I talk about this, I include here notaries, translators. Um, at the moment of its entry into force, a decrease in the demand for legalized translation was expected. It is not as it was expected because only in front of the administrative authorities this simplification is visible. But in the rest, and public notaries translation, the numbers of the documents are still the same as for the statistics are pointing. So the challenges facing the regulation are the impact on the free movement of public documents in the member states, from confirming and verifying the authenticity of the document to its translation, cost, time, and bureaucracy, and last but not least, the legal probative value of foreign public documents, as long as the regulation does not cover the legal recognition of the documents in question. In Romania, we can talk about the authentic document that fully proves to any person until its declaration as false to parties and third parties, being opposable erga omnes, and also regarding public documents which are subject to the law of the place where they were concluded, but in order to produce effects before foreign authorities, they must be subject to the authentication procedure regarding these documents. 3 years since its application, the regulation is not yet well known as it should be in the context of ensuring that EU citizens simplify the movement of certain public documents within the EU. A key word, as I said before, in this regulation is the simplification of the circulation of certain public documents, which means that bureaucracy is reduced accordingly for a category of public documents, including the apostille regulated by the Apostille Convention. So we arrived to the case law of the European Court of Justice. The second part of the analysis is considering that to understand the effects of the Court of Justice of European Union case law, mainly on national citizenship, the free movement of persons within the EU, and certain categories of public documents, we need to see the phenomenon as extremely important in the cross-border aspect of it. So we placed the Court of Justice case law in a broader context comprising decisions having effects that are widely visible and their impact at national level. There were some examples, a brief look at some cases related to the concept of family. I will point some information about the Court of Justice European Law Common case. It is a case mentioned before. It is a case directly related to Romania, in which it started from the premise that Directive 38 does not make any further clarification regarding the notion of spouses. The Court of Justice decision not requiring the recognition of the status of same-sex spouse married in another state except for the recognition of the right of residence of the same-sex spouse, a right of residence deriving from the right of free movement of family members under Directive 38. So, the object of the case is the recognition of the right of residence of the same-sex spouse, Mr. Hamilton, with the Romanian citizen, Mr. Coman, who holds Romanian and American citizenship, being married on the territory of another state, Belgium. In this sense, the Romanian citizen addressing the General Inspectorate for Immigration within the Romanian Ministry of Internal Affairs in order to obtain information on the conditions under which Mr. Hamilton could obtain the right to reside legally in Romania as a family member. The response of the Romanian authorities was a negative one, supported by the fact that Romanian legislation does not recognize same-sex marriage. In those circumstances, the Romanian Constitutional Court referred the question to the Court of Justice regarding the concept of spouse. In Article 2.2, it may be interpreted as including same-sex spouses, provided that one of them is an EU citizen, legally married under the law of a member state other than the host member state. In its decision, the Court of Justice stated that the EU respects the national identity of the member states inherent in their fundamental political and constitutional structures, strengthening the exclusive competence of the member states to define marriage, considering that the refusal prevents the exercise of the right of free circulation within the EU. Those the recognition of same-sex spouses exclusively concerns the granting of a derived right of residence to a third country national who does not infringe on issues of national identity or threaten the public policy of the member state concerned. The Court of Justice decision, it seeks to give a broader interpretation to the concept of family members of EU citizens, but we must not forget that marital status is a matter for the member states and competences, and that union law does not affect that competence, so that those states are free to accept or not same-sex marriage. Moreover, the Romanian legislation mentions the narrow meaning of the notion of family in the Romanian Civil Code, namely that the family is based on freely consented marriage between spouses, on their equality, as well as on the right and duty of parents to ensure the upbringing and education of their children. There are some other cases referred to the Court of Justice European Union provide further clarification regarding to the notion of other family members with references to unregistered partners, considering that member states have a wide margin of appreciation in this respect for the provisions of Directive 38, the concept of spouse being perceived as an autonomous concept that does not depend on the concept of marriage adopted by the member states. Ensuring the rights of such families in all member states, and in particular the right to free movement within the EU and the mutual recognition of their relationship and parenting, is another important issue in the context of major obstacles to freedom of movements in 2021. Relevant to mention in this context is the case mentioned before by Professor Campilio, case Stolicna Obștina, Rayon Pancarevo, where the Court of Justice ruled that a minor child European citizen and whose birth certificate issued by the competent authorities of the host member states designs as that child's parents to person of the same sex, the member state of which that child is a national is obliged First, to issue to that child an identity card or a passport without requiring a birth certificate to be drawn up before and by its national authorities, and second, to recognize, as is any other member states, the document from the host member state that permits that child to exercise with each of those two persons the child's right to move and reside freely within the territory of the member states. Therefore, such an obligation, you see, does not jeopardize national identity. So all this above clarifies that over time the Court of Justice has tried to interpret all these legal instruments as living tools in the evolutionary interpretation of the concepts of family, citizenship, or free movement in relation to the primary law of European Union adapted to the present society, but greater harmonization of EU law desirable in the context in which it should be noted that the European Court of Human Rights has its own approach, which quite broad interpretation. The European Court of Human Rights case law imposes a positive obligation according to the provision of Article 8 of the European Convention on Human Rights, to provide same sex couples with a specific legal framework, providing for the recognition and protection of their unions as same sex couples, but EU law does not have the power to impose same sex marriage. Recently, European Court of Human Rights was notified by application 5926 2020 in the case of SKK and HEG against Romania and 7 other claims, the subject of which relates to same-sex couples who complain that the Romanian legislation does not allow them to get married or to enter into any other type of civil union, and thus they are being discriminated against as a result of their sexual orientation and disadvantaged by the lack of legal recognition of their relationship. And they invoke Article 8 taken alone and in conjunction with Article 14 of the Convention. So there was another case in January 2021, the violation of Article 6, 8, 12, 13, and 14 of the Convention and the violation of privacy and personal autonomy for lack of clear and predictable procedure in Romanian law regarding recognition of gender identity that allows for sex change and therefore changing personal name and code in public documents in a fast, transparent, and accessible manner. So in this case, X and Y versus Romania, the applicant's transgender person submitted a request for rectification on the identity documents of information relating to sex, first name, and numerical code, which were rejected by the administrative and judicial authorities on the grounds that first, the applicant must prove that he has undergone sex reassignment surgery. At the same time, the European Court of Human Rights could not identify the reason of general interest which led to refusal to change the information in the civil status record in order to match the gender identity of the applicants. In Romania, the national legislation allows, through a civil lawsuit, transgender people to have legal approval of the change of sex in order to have legally recognized their consent, their chosen gender, followed by the change of first name by an administrative means, not by court. A change of marital status.
Lei richiede una decisione, subsequentemente bisogna inserire un
corresponding entries of the civil status documents are entered and the new identity documents are obtained. Practically, Romania recognizes that the change of sex in a legal manner, attested by a final court decision, allows that subsequent marriage with the opposite sex to the one chosen, provided that the partner is aware of the case or sex change. Um, these issues are a sensitive topic even at this moment in Romania, determined by the argument of defending religious values and moral precepts, and by the alignment and harmonization of national legislation according to the case law of the two European courts, as we are talking about de facto situation that have and will have an impact on the present and future of our society. So, in the end, I will forget. Sorry. The analysis shows that there is an undisputed connection between European case law and the right to free movement of citizens throughout the EU, one of the greatest achievements of the construction of Europe. There is no doubt that the European Regulation 1191, in which mutual trust between states authorities prevails, ensures the facilitation of the circulation of foreign public documents provided for in Article 2. By accepting them without further additional formalities, while also offering the option of multilingual standard forms and the possibility of verifying the authenticity of information passed through the IMI system. So, in our opinion, the assessment of the impact of the Court of Justice of European Union case law on the free movement of person and public documents is a positive one, as it leads to harmonization of national laws and a greater legal accepting that the EU faces a constant and difficult challenge that requires the support of all actors involved. We hope that Romania will be able to maintain a balance in addressing these issues, fulfilling its positive obligation to comply with the European Union and Council of Europe law, as well as the case law of the Court of Justice and the European Court of Human Rights, showing an equally balanced but responsible vision of human and family relationship, which will definitely focus on. So this is it. Thank you.
Thank you very much for your very detailed presentation. Are there any questions at this point? Please, Nicolas Nord.
Thank you very much. Nicolas Nord, I'm Secretary General of the International Commission on Civil Statutes. I'm not sure to get one point in your presentation. You mentioned at the very beginning that a decrease of legalized translations was expected in Romania due to the entry into force of the regulation. But Romania is part for many years now, part to our convention, ICCS Convention number 16.
Yes, it is.
And already uses them,
Yes,
these
it
two
is.
of multilingual forms. So I don't understand why you expected such a decrease, and especially because we have a very good feedback from Romanian authorities about the use of this
They use
multilingual
the
set of
Romanian
forms.
authorities very much this um, international commission formulas, but what I said, it's about the formulas on this regulation, not the
Yes, of course, but I think that there might be a switch between both of them. Why not
they
between?
considered more easy to fulfill the formulas from the international commission and not these ones. It is a matter of transparency, or maybe the citizens they are not so very sure that they may use it, and they try to use the old one. So
Of
that,
course, it's much more reassuring.
but yes, I don't know why they are not so informed about these ones. The authorities are doing their best, but the citizens, and Romania is a country in which very a lot of person has left. So now the migration is somehow balanced. It's okay. They are not going to leave. So the one there are already in other member states, European member states, they don't need any more of any of this. The one who are in the country and are informed, they use both without problems. The authorities they inform citizens, and the administrative authorities are doing their best, and I think it's a positive impact on both of the formulas. Instead, in the translations, in um, mm, legalization through public notaries, there is the still solicitation of documents. The decrease, it was about that, not about the formulas offered by the authoritative administrative.
Okay, thank you very much.
Welcome.
Any other questions?
To which extent do you think that the case law of the European Court of Justice and also of the European Court of Human Rights impacts on your law in Romania? Do you think that the way it is perceived as something that is lacking, or that there is a difference in values of the European Court of Justice, of the European Court of Human Rights, not shared by your legal system, puts pressure on your legal system to adapt, to harmonize? This is something that is a question that could be asked also to Professor Campiglio, if she said that there are two parallel identities. There's a European identity, and then there is a national identity. But if there is a European identity, the Court of European Justice tells you that maybe something is not quite right with your legal system, and you should maybe think about whether to harmonize your law. And this is exactly what the court in the end did in Bulgaria. They just recognized it. So what do you think about this pressure coming from these courts on your legal system, on your values?
The impact of the European Court of Justice is as well as important as the impact of the European Court of Human Rights. Romania respects both of these decisions. It's quite normal that the society is in this point. It's going further, but with small steps. So I think it's a matter of adapting the society. I'm not saying that Romanian institution or Romanian legislation it is not okay. It is what it is right now. I think the European law will oblige us in some terms to go further. But this is a matter of national law, so national identity. So we have to find some solution in our state, not expecting those solutions from the European Union. I think it's only a matter of time before this would happen, because, as I said before, the Pancharevo case is the first one. It will be another and another and another, and the Romania, as also Poland or Czech Republic, I don't know, all the states in European Union that does not recognize same-sex couples or civil unions will be in this situation. So acting and asking all the time in front of a court, national court, to recognize child affiliation or a parentage, it's not a solution. It's a temporary solution, but in time, with this trans-border relations, it will be a necessity. So it's to answer your question, I think it's a matter of time, and I think the Romanian society, it is not ready, but I could not tell if the whole society is not ready, or we have some differences between regions and cities, and that's all. Not more than that, I think. It's my opinion also.
Thank you. Are there any other questions? There are no more questions, I would move on to the next session. I think we're quite late already. So we have our next panelist, Eva Kaseva, the scope of the EU Regulation 2016-1191 in the light of Bulgarian domestic law is the topic of her presentation. She's an associate professor of private international law at the Institute of State and Law of the Bulgarian Academy of Sciences and at the State University of Veliko Tarnovo. She's responsible for the courses in private international law, international private family law and inheritance law, and civil law in general. And I think I'm very happy that we have her here today speaking.
Hello, do you hear me?
We can hear you, yeah?
Hello, dear colleagues. I really regret that I couldn't be with you today, and hope the next time to have the opportunity to meet all of you in person. Thank you for this perfect organization. And today I will speak about the scope of Regulation 1191 in the light of Bulgarian domestic law. We can go to the next slide. My last book was devoted on the recognition of personal status, and I made a study and summarized the methods which in Bulgaria we apply and use for recognition of personal status. The first one is traditional procedural recognition of foreign court decisions through the articles and norms of our Bulgarian Code of Private International Law. This is our General Act, which settles the relationships with international element in Bulgaria, and it has norms about jurisdiction, applicable law, and enforcement and recognition. Article 117 to Article 124 are about recognition of foreign court decisions. This is the first method of recognition of personal status. The second method is Civil Registration Act recognition under Bulgarian Civil Registration Act. Through this method, we recognize different kind of public acts, acts for birth, marriage, death, and this happen in our municipalities, our diplomatic and consular representatives, and of course there are such duties for in case of war, military persons and captains of the ships in some special hypothesis. The third method of recognition of personal status, this is the conflict of law method of recognition. This is recognition by private international law. It applies in the proceedings before Bulgarian court or before administrative authority when the applicable law, as determined by Bulgarian private international law rules, considers the status as legally valid. The identifying criterion for this method is the application of private international law rules, the reference to connecting factors that determine the applicable law. The next method is automatic recognition. This is recognition of civil consequences of foreign public acts. Example of this kind of recognition is Common Case and Pancharevo case, as the previous colleagues of mine already had mentioned these cases. The next method of recognition is recognition under the Convention on the issue of multilingual extracts from civil status records. And of course, the last but not least, recognition through the norms secondary legislation of European Union, Regulation 1191. We can go to the next slide, please. I will make really shortly, try to be shortly, general characteristic of the regulation. On the first place, the ground for its adoption is Article 21, paragraph from the Treaty on the Functioning of the European Union. The European Parliament and the Council, acting in accordance with the ordinary legislative procedure, may adopt provisions to facilitate that every citizen of the Union exercise the right to move and to reside freely within the territory of the member states. This ground distinguishes the regulation from other EU acts adopted on the basis of Article 81, for example, from the treaty, judicial cooperation in civil matters. The objective of the regulation, we can find objectives even in the proposal of the regulation, and in the preamble of the regulation in recital 57 is settled that its objective is promotion of the free movement of union citizens by facilitating the free circulation of certain public documents within the union. About the structure, the regulation consists of preamble with 57 recitals and 27 articles divided into 6 chapters, and also contains 11 annexes. The next slide, please. As far as it concerns its Ratione temporis in Bulgaria, it's applied since 16th of February 2019. Article 27, paragraph 2, letter from A to C, explicitly defined provisions that apply from earlier dates in view of the necessary preparation for regulation implementation. About Ratione Loci, the regulation is binding in its entirety and directly applicable in all member states. About the relationship with other instruments, it's settled in its, as far as it concerns international instruments, it's settled in its Article 19, paragraph 1 and 2. Relationship with European Union acts is settled in Article 17. And relationship with Bulgarian domestic acts, the regulation shall be applied with priority over the internal acts of the Republic of Bulgaria, according to Article 288 of the Treaty of Functioning of European Union. The next slide, please. About Ratione Materii of the regulation. In Article 2 is defined the scope of the regulation. It applies to public documents. They are defined broadly in its Article 3, paragraph 1, letter A. Applies to issued, this kind of documents should be issued by the authorities of the member states in accordance with their national law. Primary purpose of this kind of documents have to be to establish one or more of the facts settled in Article 2, paragraph 1, letter from A to M of the regulation, and have to be presented to the authorities of another member state. It applies also to certified copies and electronic versions, and excluded from the scope are copies of certified copies, documents issued by private persons, public documents issued by the authorities of a third country, public documents on the change of a name, passports or identity card issued in a member state, civil status documents issued on the basis of the relevant International Commission on Civil Status Conventions. And one nota bene, the regulation does not apply to the recognition in a member state of legal effects relating to the content of public documents issued by the authorities of another member state. And now, thank you, I will present the public documents in Bulgaria which certify the facts listed in Article 2, Paragraph 1, letter from A to M of the regulation, which are included in the scope of the regulation. On the first place, for birth in Bulgaria, we issue a birth certificate under Article 42 of our Civil Registration Act. It is issued by civil status officer or drawn up by the respective Bulgarian diplomatic or consular representatives or by the foreign local civil status authorities in the place where the event subject to registration took place. To certify that the person is alive, we have a certificate for children born from the mother. They are issued on the basis of Article 16 and Annex number 7 of Ordinance number 226 for issuing certificates on the basis of the population register in Bulgaria. For the death, we issue a death certificate by a competent medical person who shall report it to a civil status officer. The officer shall draw up a death certificate within 48 hours of the death. It has regulation again in our Civil Registration Act. In case of death of Bulgarian citizen outside the territory of the country, a death certificate can be also drawn up by the respective Bulgarian diplomatic or consular representatives or by the foreign local civil status authorities. The next slide, please. About the name, we issue birth certificate of identity of a person with different names, court decisions, and we have one special procedure which is set out in our Civil Registration Act for restoration of the names by a decision of the civil status officer. It is about one process of changing the name of the Bulgarian people with Turkish roots, which took place in the 80s from the last decade. About marriage, we in Bulgaria issue marriage certificate. It is again set out in the Civil Registration Act and also in our Bulgarian Code of Private International Law. We have norms about the conditions for marriage and this is Article 76 of the Code. About the capacity to marry, documents establishing the existence of the conditions for marriage are a declaration by each of the spouses that there are no obstacles to marriage, a medical certificate that he or she does not suffer from the diseases which are referred in Article 7, Paragraph 1.2 and 3 of the Family Code of Republic of Bulgaria, and declaration that the other spouse is aware of the diseases of the other spouse under already mentioned Article 7 from Family Code, and the decision of the district court in the that one of the persons who will marry has reached 16 years of age. This is a special hypothesis. The next one, thank you. About marital status, again, ordinance under our ordinance number 226, we have three types of certificates that establish marital status. The first one is marital certificate. There can be entered that the status is unmarried, married, divorced, or widowed. The next one is a certificate of marital status, spouse, and children. It includes the marital status of the person, data on spouse, and all living and deceased children. And on the third place, certificate of spouse and family ties is issued to prove marital status and existing kinship. About the divorce and marriage annulment in Bulgaria, we issue it's certified by court decision. We apply Article 380 to Article 330 of the Civil Procedure Code of the Republic of Bulgaria in connection with Article 49 to Article 59 of the Family Code of the Republic of Bulgaria. And of course, if there is an international element about the relationships, we apply provisions of the regulations in the matter. Regulation Brussels 2 bis, Brussels 2 regulation Rome 3, etc. About the next slide, please. The registered partnership and legal separation, they're not regulated in Republic of Bulgaria in our substantive law. But if the Bulgarian court applying the provisions of the European Union regulations to a case should apply a foreign law in which the respective institutes are regulated, and as a result of this, an act is issued certifying the fact listed in Article 2, Paragraph 1, letters F, G, and H of the regulation 1191, this document is regarded as included in the scope of the regulation. About parenthood, the relevant documents falling within the scope of the regulation are a birth certificate, an act of a judicial authority issued on a claim to establish or challenge maternity, paternity, a written application for recognition, a declaration of recognition with an authorized signature, as well as the documents for challenge of recognition, different kind of documents. In the scope of the regulation, as official documents establishing the parenthood under Bulgarian domestic law should also be included already mentioned certificate, marital certificate, certificate of marital status, spouse and children, the certificate of spouse and family ties, and the certificate for children born from the mother. Here I will mention again the Pancharevo case. Just to add something, I would not explain the case, you know all the facts. Currently, the court, what happened currently in Bulgaria, the court returned the case to the municipality to issue birth certificate, but now the municipality could appeal on its turn, and we don't have information is the certificate going to be issued or the municipality is going to about this decision, I think that with this decision, European Court of Justice held that European Union member states are required to recognize for the purpose of European Union Free Movement Law, the familial ties established in another EU member state between a child and its parent who are a same-sex couple. And in my opinion, this case is an example for automatic recognition of personal status, as is the common case. On the basis of mutual trust, one state accepts and recognizes the civil consequences of a legal situation settled in a foreign public act, which has arisen in another state without changing its substantive law, and even if the applicable law and relevant rules in the host state are different. Please, the next slide. About the adoption, we issue birth certificate. It can be settled in court decision, transcript of birth certificate, full transcript of birth certificate, and certified copy of birth certificate. About the concept of domicile, we have a certificate of permanent address and certificate of present address, a certificate for changes of permanent address, and a certificate for changes of present address. In our Code of Private International Law, we have a definition of habitual residence, Article 48, paragraph 7. And this is the place where a person has been established to reside without this being related to the need for registration or a residence. And there is no need of permission. We only take into account personal or professional circumstances arising from the person's relationships. About the residence of foreigners in the Republic of Bulgaria, we issue visas as well as permits, certificate for long-term, permanent, or long-term residence. About the absence of criminal record, there is a special certificate, criminal record certificate, which is issued under Ordinance number 8 from 26th of February 2008. About voting, in Bulgarian voting code are set out different kinds of declarations, which have to be presented in the municipal administration at the address of residence by the persons who wish to vote in non-national country or to stand as candidate to the European Parliament elections in non-national country. All official documents required to be presented by citizens of the Union residing in the member state of which they are not nationals when those citizens wish to vote or to stand as candidates in elections to the European Parliament are included in the scope of the regulation or declarations under our voting code. And I sum up three conclusions. On the first place, the scope of the regulation is very broad, and through it is achieved one of its purposes, facilitating the free circulation of certain public documents within the Union. On the second place, Bulgarian law has detailed regulation of four of the institutes that are set out in Article 2, letters from A to M, scope of the regulation, and there is no obstacles for the application of the text of the regulation. And the last one is my conclusion connected with the Pancharevo decision. I think that decision that the regulation would not apply to the recognition of legal effects relating to the content of public documents issued by the authorities of another member state, but only serve the sole purpose for verifying the authenticity of public documents is controversial because the practice and the life there are many cases, and they will maybe in the future we'll have many cases, and I think that it's controversial, this decision, to fall out of the scope of the regulation, this question. Thank you for the attention.
Thank you. Thank you very much for interesting presentation. I'm sorry to be stressing here, but we have to move on to our next panel, and we've run out of time, unfortunately. I don't know, maybe if there's one question about your presentation. There does not seem to be any at the moment, so thank you again for your presentation. And I think we can move on to the next panel now. I've been asked to say that the dinner will be postponed a bit accordingly to our delay. So thank you again to all presentators, all panelists, and thank you.
Non lo vedo. Se c'è, gli cedo il... ma non c'è. No, non c'è. L'ho vista. So, hi everybody. I think my nickname would be in Italian prezzemolo, parcel. That's what Italians say, that parcel is everywhere. And unfortunately, I'm taking the chairmanship of this panel. It was envisaged to be chaired by Simon Reisteg, but unfortunately, he could not join us due to the oh god, strikes of Ryanair and many other companies in Belgium and the Netherlands. So he almost feared for his safety, so he couldn't join us. And I don't see Rob van der Velde, who's the other EVS representative. So I'll be chairing this out of necessity. Sorry again for hearing me twice today. And we'll move on very quickly. This session, closing today's work, is devoted to the practical tools we've developed for registers in the European Union. So what everyone got right upon registering for the conference was the handbook that we've been publishing these days. This is the Italian version, is the original version. And I must say, it's mostly the outcome of all the efforts of Dr. Giacomo Cardacci, who drafted most of the parts of the handbook. So he'll be introducing you very quickly to this handbook on the language versions that are upcoming, still on the way of being layouted and reviewed. And Thomas Tigari is an expert of ANUSCA, so our host, and he'll introduce you to the FAQs that you find already on the website. And as part of the tools we will offer on the website aimed at familiarizing registrars and professionals on the regulation, there's more to come in the coming weeks. So I'd say you'll start, since you already there. So tell us something about the FAQ.
Thank you. After deep thought about the project, now I try to present a more practical perspective, and I switch to Italian if you don't mind. Ok. Il regolamento ha introdotto
introduced beyond the exemption from legalization multilingual forms that present a higher difficulty in their creation, because compared to other international treaties like the Wien Convention, has a higher number of languages. Thank you. So in the practical implementation of the regulation, the European Commission understood the need of introducing online tools for the creation of these documents that have already been analyzed on the handbook. So tools to create multilingual forms, but also tools to gather copies of different countries, and also to have an overview of the situation of single countries that can be found on the website of the European Union. I will try to be quick because we are running out of time. You can find these forms both in the handbook and on the website, as we have said before. I don't want to focus on these aspects. I would like to highlight that on the website of the European Union, you can check up in the different languages of the Union. You can just switch languages, selecting the one you want to use. And what concerns the creation of multilingual forms, you start choosing the form you need, then you choose the destination member state and the official language. These are just some screenshots of the forms, but I don't want to focus on this topic now. It's interesting that on the website of the European Union you can get general information on the different member states and on what they offer. At the same time, the member states have presented an archive of a repository of most commonly used public documents. Some states have posted more documents than others. That's true. But at the same time, also the European Union has presented some FAQs, that is to say, frequently asked questions, which are quite few. They were updated to 2021. This is different. What did the project Identities on the Move do? The website is quite interesting. Beyond analyzing the project, explaining the scope of the project, you can find news, updates, but also publication and resources. In this sector, you will find the handbook, the different languages of the European Union, and also other resources that will be available during the project. This is a section that will be steadily updating. Another interesting tool is the national and comparative reports, especially for users, because many times users need to have an overview of the situation in different member states. Such a tool was missing, and I think that will be appreciated by different registers, because this is something that helps a lot. It's really interesting also to have a commentary to the regulation, article by article. This is also was included in the current overview that was not available yet, but this is a fundamental tool. From the debate among the users and scholars that took part in the project, we understood some frequently asked questions. So issues that were present more than once. Of course, in the regulation, there are some uncertainties. There are some issues that should be solved. Some of them were also unexpected because they were changing from country to country. So we tried to create, to develop standard answers to different questions, that is to say, FAQs. This also will be updated over time. I think that now the number is 20 questions, and they are useful. You can look them up because they answer to different questions that will be really frequent in different aspects. You can find them in a specific section of the website. And they provide solutions to issues which are not expressly enshrined and analyzed by the regulation. As we said before, for example, the issue of religious marriage, how should be a religious marriage treated? There are also some clarification on the MIM system. We will go deeper on this topic tomorrow, I think. And there are also clarification on doubts that were present in some countries. For example, the extent from legalization when multilingual forms are not present. So these issues were present in some countries, arose in some countries. For example, in Italy, at first we had some doubts. So FAQs try to solve two different questions. that is a useful tool, and they have a practical impact. So this tool will be useful now, but also in the future. I think that users will need to keep an eye to the website of the project, maybe subscribe to the newsletter to get all the new information and the updates on the regulation. Of course, in the recent times, we had an increase of these kind of tools that will go on also in the future. This is the list of the current FAQs we have at our disposal. I don't think that is much to say. We are running out of time, so maybe we can stop here. And maybe you can include the website on the favorite site so that you can always have it at your disposal. Thanks a lot for your attention.
Ci introduce, è già disponibile online, la versione italiana,
which is downloadable online. But as I said, there are some thousands copies per language which will be printed. So as you can see, you have the Italian version. I used this occasion to say that the dinner was late by 30 minutes, so we will start at 8:30. We ask for sorry the interpreters who are online. I'm not following, but I think they are kindly helping us with this delay, so I thank you for this, for your engagement and for not stopping too late. I will try my best. Good evening, everyone. My objective is to make a presentation of maximum 4 minutes. So I will proceed very quick. The interpreters won't be happy. As Alexander Schuster said before, I wrote the handbook together with him. The handbook is a manual, practical manual or instructions manual about the regulation 2016-1191. The target who we thought of are the civil states people, but it's also very useful for lawyers, for the private sector. Alexander Schuster was taken as example the companies which might have the need to exchange some documents of their workers or of the citizens of the United Nations. The handbook is in two formats. As you can see here, you have the paper form and the e-book with a linked PDF, and it's downloadable on the website, and it will be in English, German, French, Italian, and Greek. Less copies than what was expected will be printed, not because we don't need them, but because we're very environmental friendly. So in the beginning we were thinking of thousands of copies, but there was also a little debate about this. I would like to show you where is it downloaded? The handbook? Yes, the handbook. 4 minutes are almost over, so don't worry, I just wanted to show you how we conceived it. give the authors this satisfaction, this personal satisfaction. The handbook is divided in 3 parts. The first part talks about the life cycle of the regulation. According to an intuition of Alexander, we had to tell about the life cycle of the public document. So its birth inside of a state, its journey through the states, and its landing in another state. So beyond the first 3 articles, which are just to give you an idea of the regulation and the application areas in the time and in the space of the regulation, there is like a timeline which can be followed, and to follow the story of the regulation. There is a second part which has a sort of description of all the member states with useful data about each state, and the third part with the regulation. As you can see, it's very practical. There are some boxes where you can deepen some topics, and other links to other conventions or to other parts of the regulation which are in blue. I would like to end my speech by saying that I would like you to download it if you like, and I would like to thank Alexander Schuster, because this European project, I saw different European projects, but this is really excellent. The handbooks are nothing more than small books in which the authors just republish their essays without any practical suggestions. But this handbook, is something which is extremely different, and it's extremely useful, and is connected to high-level scientific books. I would also like to thank Professor Laura Calafat. Thank you very much. Thank you, Giacomo. You will tell us whether the objective of giving something useful instead of a paraphrasis of the regulation has been made. The fear was to say something wrong. As you can see, we tried to analyze the issues and not to give the solutions that we all have. So we hope that the handbook and Giacomo's work is appreciated. We made some delay. Tomorrow we have to be fresh here at 8:45 because there are some parallel sessions, and we need to be precise. We cannot be late. We need to respect the timetables. We try to put some breaks for occasional delays, but we cannot do as we did today. I forgot what you have in the Dolomites, the chains of the cows, which are a clear signal. But tomorrow will be different. Now we're going to jump into the swimming pool, and at 8:30 dinner by the pool. See you later.